Welcome to this IP speaker series. My name is Bradley Fung. I'm the Education Program Manager at New Ventures BC. Today's webinar is on public disclosures and IP rights. Before we begin, I want to take a moment to acknowledge that, at least myself in Vancouver, I'm here on the unceded territory of the Musqueam, Squamish, and Tsleil-Waututh First Nations. Very grateful for the opportunity to live, learn, and work here as well. Excited to have you here as well. Before we get started, just a couple housekeeping notes from our team. Please ensure you're on mute unless you're called upon. If you have any questions that come up over the course of the webinar, I invite you to use the chat function at the bottom of your screen. Greatly appreciate this. Just really helps us stay organized as a team. If you feel comfortable doing so, I also invite you to turn your camera on. Always helps us feel more engaged with our audience as well. Uh, by coming here, I think you're all taking a great step in kind of pursuing your IP education. If you're interested in continuing this as well, I invite you to apply to our IP Pathways program. This program is designed to provide you with the fundamentals of IP and align your IP strategy with your business strategy. It's delivered monthly on a flexible model, and I'll attach a link in the chat with more information once I'm done. Today, we're joined by our host, Byron Tom, and our guest, Miles Steininger. Miles here has helped his clients stay independent and return over $2 billion to investors. He has practiced IP law as a patent agent and as IP manager in startups, medium-sized and multinational public companies, as well as in private practice. Today, Miles is a partner in Perpetual Motion Patents of Burnaby, where he focuses on crafting IP plans, preparing and prosecuting patent applications, and delivering IP education. And with that, I'll introduce you to your host for the next hour, Byron Tom. Byron is an engineer and a lawyer. He has practiced at one of the leading IP boutiques in Canada, helping startups and multinationals protect their technological assets. He's a startup founder, venture capitalist, board member, and patented inventor who's drafted and prosecuted his company's own patent applications. He now works with companies to develop IP strategies and focus their resources on key assets that matter to the business, to investors, and to potential acquirers. I'll pass it off to Byron. Hope everyone enjoys the rest of today. Thanks for coming.
Great. And thank you, Bradley, for that introduction. And thanks, everyone, for joining this afternoon in bright and sunny BC. Hopefully, wherever you are, it's also sunny. It is definitely that here in Vancouver. As Bradley mentioned, my name is Byron Tom. I'm a partner at BDC Capital at one of the direct investing arms. So my fund is called the Industrial Innovation Venture Fund. It's $450 million investing across Canada in industrial innovation, including advanced manufacturing, ag and food technologies, and technologies for extractive sectors, as well as horizontal technologies that can play into those sectors, including AI for industrial, analytics for industrial, and robotics. As Bradley already mentioned, we're very grateful and thankful to be situated on the traditional lands of the Coast Salish people here in Vancouver, including the Musqueam, Squamish, and Tsleil-Waututh. But I also want to respectfully acknowledge that many folks are joining us from places near and far, and want to give thanks and gratitude for the original caretakers of those lands as well. As Bradley mentioned, today's topic is on public disclosures and their effects on IP rights. And we have an expert in Miles Steininger, who is going to walk us through lots of different things that startups and scale-ups should be thinking about as they go about marketing their technology and their companies, but at the same time thinking about IP rights and impacts of those public disclosures on a multitude of different things. So rather than expand on Bradley's introduction to Miles, I'm just going to hand it over to Miles himself to say a few words about him and his practice, and then we'll get right into the topic. Welcome, Miles. Is there anything you'd like to add?
Words about me and my practice. Well, I am the patent agent in Vancouver that is most desperately in need of a haircut. If you want to challenge on me, I'm all ears. And then my practice is kind of fun because I really split between deep tech, quantum computing, robotics, AI, and then more tangible things. For instance, I specialize in people innovating in the area of construction or building technology.
Very cool. Okay, I'm sure maybe we'll get into that a little bit more as we get into the discussion. But let's start off on providing some definitions for this audience, understanding it's mostly startups and early stage companies. What is a public disclosure and why is it important and relevant to the patent process?
A public disclosure or a publication, and I do prefer public disclosure, is when you make information available to the public. disclosure the opposite of enclosure. So why is that important to patenting? Well, patenting is all about disclosing information in a patent application with the hopes you get rights back. So a disclosure or a publication can be something that bars someone from getting a patent.
Right? Because the three aspects of patentability, right, are new, useful, and non-obvious. Right. And so maybe a quick reminder, what is anticipation and what is obviousness with respect to public disclosures?
So you can have, and maybe, sorry, what is an example of a public disclosure? So you could have a book, an article, and those are really tangible things we'll talk about. There are other examples. You could have information in a book and an article that anticipates the content of your patent application. That basically means the content of your patent application is found within that book or that publication. Sometimes we even say within the four corners of the document. It's all there. Another way a publication can affect a patent application is if it can be used in an obviousness argument. Some part of your patent application is found in a publication. Now, maybe we have to take two references, two publications, and combine them to get everything that's in the patent application. Or maybe we have to take something in a reference and modify it. And that's where you make an obviousness argument by combining or modifying.
Okay. And I guess with regards to public disclosures, you're kind of anticipating your own claims, so to speak, in having a public disclosure and prior to filing. What are the requirements in terms of timing? Like, is it just you offer for sale, right? Or you have a piece of marketing material and all of a sudden you can't get a patent? How does that work?
Yes. So the different ways you can make a public disclosure. You can have a publication, book, article. You could go to a trade show. You can release a podcast. You can have an offer for sale. It's available for someone to buy. That would also count as a public disclosure. How does this affect your patent rights? It depends largely on the country you're talking about. In the US and Canada, they give you a grace period of 12 months, 1 year exactly, in which you could have a public disclosure and later file for a patent application. However, in other major patent offices, principally the European Patent Office or the Chinese Patent Office, the Sino Intellectual Property Office, that's not possible. Once you've made a public disclosure, you're barred from getting patent rights. So we differentiate between countries of absolute novelty or patent offices of absolute novelty and those with a grace period, such as the US and Canada.
So that also means, so I guess what you're saying is, right, if you want a patent in Europe or in China, it is a requirement by law in those jurisdictions to file prior to making a public disclosure that, right, renders that anticipates or renders your application obvious.
Yeah. We're principally talking about anticipation in these cases, but yes. So if you want something in an absolute novelty country, file first, release second.
And what is the level of disclosure that's required in order to anticipate? How, like, when we talk about offer for sale, right? If we just show it at a trade show, we don't let anyone actually touch it or take it home. How does that? How have courts or how do people think about that as anticipation?
Well, Byron, this is really difficult to give blanket advice because the details of the disclosure will matter. And the industry will matter and things like that. There's a lot of complications. So one thing that I always ask about is, could a salesperson make a sale? So is it available on a price list? Can that be put through in the system of record? So I worked in a company once where everything went through PeopleSoft, even the sales. And it wasn't available. There's just certain products weren't available until certain dates. I was dealing with a client yesterday And I asked, well, can you make a sale about this? And they said, well, no, because we only have one salesperson. I said, well, what about your factory? They said, we haven't retooled. So that's a different scenario. So the first company was software. We're talking about consumable goods or packaging goods. Next example I would point to is pharmaceutical. You can have a vat of an active pharmaceutical ingredient sitting there, but if it isn't pharmaceutical pure, it's not available for sale. The details of your industry will matter. If you have an article sitting there at a trade show, I kind of need to know what you can see in that sample sitting at the trade show. Is it behind glass? Is the function of it obvious? Apparent, not obvious, pardon me. Is the function apparent from what you're seeing? It really, really depends. And this is where a conversation between the client and the patent agent is really, really helpful, because the client's usually able to provide just a few details that really then hone on to, is this thing available to the public or not?
Okay. And so there is a lot of nuance there, right? Particularly as you're going from anticipation, which right, which is a direct bar to the obviousness aspect, and being able to determine what is that unique thing that makes the patent overcome any objections that they might occur from an examiner at one time or another. Oh, interesting. Okay, and so what do we do about this then, right? And so we need to go to trade shows, we need to talk about, and we need to raise capital for our startups. And so how do we think about best practices when dealing with that kind of dichotomy of, I need money and I need sales in order to be able to pay for the patent application? But right, by making those public disclosures, they may vitiate my rights at a future date.
Well, nobody said this stuff was easy. I am a patent person. That's how I've made my living for decades now. But I am very pro companies selling things. That's why you exist. You want to attract and retain customers. So people are surprised how pro I am to come down and make the sale. But there are techniques you can use. So for example, you don't actually have to offer something to sell to engage the customers. You could talk to the customers about the advantages of your solution without disclosing the solution. You can file a provisional patent application. That's a great way to preserve your rights to file in further countries. Or you can look at your patent strategy, which of course you have. Even if it's rudimentary, you still should have a patent strategy, and consider, well, we were only really ever planning to go after the US market, or maybe the US and Canada. We're going to sell now, patent later.
So relying on the grace period, knowing that you have 12 months, and then just regarding the rest of the world, right? Or ones that require absolute novelty from gaining patent protection.
Right. And this can be a very sensible, pragmatic business decision. Make it a decision. Don't sleepwalk into this stuff. Make an active choice. And as long as your active choice is within the spectrum of reasonable, don't beat yourself up about it. Oh, I wish I had done this 6 months ago. Guess what? You did something reasonable, move on. It's only when your actions are unreasonable, is it worth revisiting and, thinking, well, I could have done it differently.
Okay. And so if we think about the provisional patent application as one of kind of the easy ways to lock in the ability, what are some of the advantages of a provisional, and how should companies think about, if that's kind of a very common way of going about this, how should they think about when to file a provisional and what's included within the specification?
A provisional application, file early and file often. You can file a provisional application today, get a filing receipt, update the content tomorrow, and file again. The cost of doing so is my fee. The cost at the US Patent Office right now to file a provisional application is $130 US. It's quite cheap. So file early, file often. Now, what to put in there? I come from the school of thought that it should be as close as possible to the patent application you want. So it really reads and looks like a patent application, has the sections in a formal patent application, ends with claims, has the best diagrams you can. They can be hand-drawn, but they need to look like patent diagrams.
And so what's the thinking around that? Why does that matter?
I'm getting in trouble for saying this. So did you know that OnlyFans was originally developed for musicians? And I'll
I did
explain
not.
what I mean by that. Okay, Byron is not an expert on OnlyFans. It is a website used for pornography. It was originally developed for musicians. The provisional patent system was never developed to help small companies. It was never meant for thin patent applications, where you just take a manuscript, wrap it in a bit of text to make it look like a patent application, submit it. The design of the provisional patent application system was to help Americans get a US patent that expired 21 years from their first filing in the United States. Patent agents looked at the requirements of a provisional patent application and said, hey, there's no requirement it has claims. There's no requirement for signatures. We can put almost anything in them. So sometimes you're in an emergency, you want to make a sale, you want to go to a trade show, you file what you have that day. It's a thin provisional. You can
just
start
take a bunch of documents
tomorrow.
together, a bunch of drawings together, and pay $130.
Just done. And you've got something,
Mm-hmm.
you know?
Other
It's an
cases where I
option.
see this a lot is in the academic sphere, where you're just about to publish a paper,
Yeah.
or other circumstances. Maybe to say, okay, so trade shows, right? You're going to make a first sale. Maybe you're publishing a paper. Any other situations where it makes sense to just slap something together?
Trade shows is a great one. Of course, academics. You're talking to a partner.
Mm-hmm.
You want to disclose some technical information to a partner, and you want to establish that everything you disclosed, you want to separate your background IP from the foreground IP. So everything in that provisional is background IP that belongs to you. And anything your partner suggests in the meeting, you might politely say, oh, yes, that's a good idea, knowing that's already in your provisional patent application, preventing them from claiming contribution to the invention.
Yeah, very interesting. And maybe just talk a little bit of provisional from an easy filing perspective. You pay the fee, but my understanding is it doesn't actually get opened, right? No one can actually see what you file unless what happens.
So Gergely Zamani was at Shervin Morrill McPherson when he explained this to me. He said, you remember the end of Indiana Jones and the Lost Ark, or sorry, Indiana Jones, Raiders of the Lost Ark. Remember the end of Raiders, where they take the Ark and they put it in a box and they wheel into this huge warehouse. He says, think of that as where your provisional patent application is going. It just goes into the pile. And it sits there and it gives you the option, not the obligation, to file a non-provisional application. And if you do that, the contents of that provisional application will become public. There is another option. There's actually three options. Another one is you just do nothing. And another one is you expressly disclaim any patent rights in that provisional, which can be advantageous in some scenarios.
And then what happens in those two scenarios? So what happens if you do nothing?
So if you do nothing, you can't really use the Paris Convention to file in other countries again. You've lost your ability to file that same invention elsewhere. If you expressly disclaim it, pay a very small fee and say, hey, I never really wanted to file this in the first place. You don't even have to say that. Just say, I don't want any further patent rights on this. Then you preserve the rights to file another patent application on the same topic.
On the same topic, yeah. And then if you do any of those two, it won't be published as well, right? So then it can't be cited against you, right? No one can see how badly you draw your figures.
All your typos are hidden. It's awesome.
Yeah, there you go. Okay, so this is a nuance then. And so what happens if you file a provisional application and then wait more than a year? It doesn't get opened, and so you can't claim priority, but can you not file a non-provisional after that with the content of the provisional application and just hope no one came in between?
If I wait 13 months between my provisional and file a US non-provisional and don't claim priority, that's improper, but I can't explain why you would. I guess you just can't, you don't benefit from the provisional filing in the
Yeah, you
US.
don't benefit
Yeah.
from the earlier priority date.
Yeah. Yeah.
Mhm.
So we're often, when you're talking about with a patent agent, you often have a very simple timeline, which is being with the patent agents coming up in their head. So sometimes it's really helpful to just put this on a whiteboard, and then it makes the answer a lot clearer.
Yeah, for sure. Okay, and so anyways, the provisional, I think what we've come to is a provisional is a magic document, at least for early stage filings, in order to protect rights that you may or may not want to do with something with in the future. So it's a bit of a time machine for early stage companies to just lock in a priority date that they may or may not use. How do we think about going about this? You said you could file every day, which probably does rack up a certain amount of cost and is probably not recommended. But what are some strategies in terms of filing provisional applications as people go along? So we talked about, hey, when there are key events that happen, but is there anything else that you should be doing or companies should be doing to be collecting the information to be ready for an emergency filing if they know that a public disclosure is upcoming?
Oh, absolutely. If you have good documentation, something gets moved, there's a chance that something could be moved up. Releasing a product takes a bit of effort. It takes some coordination. So if you think that might happen, then do get the technical information about it together. You have your external events, sale, meeting with a partner. You also have your internal events. If you're in an industry where innovation is won through hard-fought testing, you have your research milestones. And when you hit those, you have the data. That's another time you might want to file a provisional. And so where are two very common industries for that? One is anytime you're testing basically a chemical for a certain function, or in machine learning.
Can you expand on those a little bit? So I think we're getting into utility here,
Yeah.
and maybe we'll come back to it in a little bit. But right, I think you're talking about adequate disclosure and enabling, right? And so if you don't have kind of or predicting, right, the utility of something if you're not actually sure yet.
Yeah.
So maybe can you explain that a little bit for our audience? Because right, probably lots of folks here are not in the biotech sphere and drug discovery, so are probably not that familiar with what sound prediction is and enablement. And so it would be helpful to kind of continue this conversation.
So we often say, and I think wrongly, but let's not dwell on that to get a patent, it has to be new, useful, non-obvious. I'd also point out to get a patent, you have to pay money. So the list is obviously incomplete, but in the middle there is useful. And utility is a topic whose importance varies with the subject matter. If you make a mechanical device, it's pretty evident whether it's useful or not. But in topics like machine learning or pharmaceuticals, utility is incredibly important. So let's focus on pharmaceuticals. You can apply for a patent application in Canada before you know you have utility, before you know that substance will do the thing you claim it does. So how does that work? If you're required to have utility, but you can file before you've demonstrated utility, if you can soundly predict on the basis of a factual basis, so basically having experimental data, plus a sound line of reasoning, there is a theory why this data indicates we'll have this utility, and you disclose those two things, the data and the reasoning, in your patent application, then you have soundly predicted it, and you can get a patent application. So going back to why does that trigger a milestone? Well, once you have that data, file a provisional.
And what happens if you don't have that data?
So get the data. If
Right, but
you,
there are lots of cases where, okay, the courts will claim, or someone will be able to invalidate the claims because at the time, right, it's a little bit of a historical uh, game here to say, hey, right, without getting into the legal specifics, no one would have thought that that would have worked at that time, right? And
so
so you can't just randomly claim the world
you
and
can't,
get patent protection.
yeah, absolutely. Don't randomly claim the world. So this is where the serial provisional comes into play. You have certain research milestones. You have a little bit of data. Well, then file on it. 3 months from now, you have more. Well, then plan to file more then.
Yeah. And I
And
think this is a little bit of the specifics for claim construction, which you can have a new use for a known compound, which is very common in the pharma world.
yeah.
And so sound prediction is so crucial if you have a new use for something, because that new use is what's novel and that you can claim protection for.
Yeah.
Right? You're not actually just claiming the composition itself because that's been discovered previously.
Right. And that's why AZT is a substance used in the early days for treating HIV. And it was a known substance, known back to this was sort of in the 80s, and then substance was known to the 1950s, when it was believed that cancer was primarily caused by viruses. Now, some cancers are produced by viruses. So AZT was something that was an antiviral. And the case law on sound prediction has to do with that substance AZT from 2002 at the Canadian Supreme Court.
Right. I think similarly, right, you think about on our OnlyFans topic, you talk about sildenafil, right? And the new use of a hypertension drug for lots of other uses.
Yes, it is.
But it was the utility of that new use that became quite valuable, right? Not the actual composition itself, because that had been discovered years previously.
And the utility combined with a known substance that's very common in pharmaceuticals. I would also point out in machine learning, demonstrating utility is and also unexpected results and obviousness. It's kind of so if you get good results, file a provisional. Now, let's say you're a software company or you're in mechanical engineering space. You don't usually need to file as many provisional applications. Usually one is enough.
Can we dive into the machine learning? Because this is something that I have not seen being out of practice for so long. Like, what are some of the objections with regards to utility that people who file machine learning applications are encountering?
Well, quite simply, if you take some data and apply feed it into a neural net, does it actually produce a useful result? So if I take a cell and I apply a substance to it, do I get a beneficial effect? It's the same sort of considerations. I also find it really interesting. There are analogies between how we think about invention. And would it be obvious to try this? And it comes in, yes, it would. Yes, it would be obvious to try. Would you have an expectation of success? Sometimes in machine learning, you just don't know.
Yep.
I mean, the thing that we all talk about these days is ChatGPT. We use ChatGPT to mean all the large language models. And what does that T stand for? It means transformer. And that was descriptive of that technique. And lots of people didn't think that transformer function, I won't go into the details, would work. I guess what it did, quite unexpectedly so.
Interesting. And so has OpenAI filed a lot of patent applications then, right? Have many of them gone through?
I haven't done a survey of them for a while now. Yeah, there are tons of applications on large language models. Some of them going through. OpenAI itself seemed a little late to file last I checked. But because it takes 18 months for your patent application's priority date to become published, and it's been about a year since I checked, I'm a little out of date.
Yeah, no, fair enough, right? Definitely, we do know that the hyperscalers are filing frequently and often. And so even if the startups, which query whether or not OpenAI is considered a startup, does. For sure, all of the hyperscalers are. They have very large patent filing budgets. Okay, so we've talked about creating a culture of proactive filings, right? So when you get these milestones, when you get sales, when you're about to offer something, maybe kind of let's take it down to how you're seeing it within some of your clients. What are like the mechanisms that companies are creating in order to be able to do that? Is it just everyone sitting at an executive meeting saying, okay, well, we're about to have like this big thing, we should file something? Are there, do you hand it off to an IP specialist? Do you do it on a monthly basis? Like, what are some best practices you can share with our audience today?
Mm-hmm. Well, I'm recognizing some friendly names here, and many of them are in smaller companies. So I'm going to presume that my non-random sample, the people I recognize, is representative. So let's say, what do we recommend for smaller companies? So I recommend having a simple spreadsheet where you track your innovations. Every innovation that's worth tracking gets a number. It doesn't even need to have a name, as in a title of the innovation. It gets a 1-paragraph description, a contact person, doesn't need to be an inventor, just somebody who can speak to it, and link to existing documentation, plan disclosure date. Very simple record. Why do you do this? Was because as you are building the product, designing the product, building the product, testing the product, you may realize some aspect of it provides an advantage, seems to have novelty, is technical in nature. Well, okay, just put it in the list. And then quarterly, you can go back and say, and quarterly is a pretty good cadence, well, what of these stand out? And then it's pretty easy to evaluate and say, oh, that one's great. Let's ask the creators for documentation. And if they don't have any, ask them to write it. And then make a decision about whether to protect this or not.
Mm-hmm. And then what are your thoughts on building like super specifications and with multiple sets of claims?
Ah, that's another way. So if you can omnibus it, you absolutely can put more than one patent invention into a description in the drawings. You can even have multiple claim sets. Absolutely recommend doing that. You want to be able to have templates that support the ability to file early and file often. And so once you sort of learn the game of how to rearrange the patterns, you can, if you have 2 related inventions, put them together. There are other tricks you can do in the US, or you can have incorporations by reference and citations of each other. But yeah, very simple way to do it is first invention for 10 pages, next invention for 10 pages.
Oh. And so these are ways, or simple ways that I guess startups can get a priority date, so file in order to get a priority date without kind of blowing the bank, with the fees required, right? You're still going to have to go through the process of drafting a specification, creating figures, drafting claims, because that's the best way to prepare yourself for filing a non-provisional. But it's still important. Like it can be a good method, and I've definitely done that lots of times, and I've seen lots of companies that I've worked with kind of slap a bunch of things together, file once, and then decide in the next year which one they actually want to take forward. And then to your point, Miles, right, in the US, you can use a bunch of different situations to be able to kind of split divisionals, continuations, all the rest in order to be able to get utility, right, or get issuances out of, right, a larger application that you might have filed once. I do see there are a little bit of questions in the chat. So Miles, I'm not sure, some of them are actually quite interesting. If you want to tackle any of them now, but maybe I should have said at the beginning, if anyone has any questions for Miles, please do write them in the chat. We may not get to all of them in the 25 minutes that we have left, but we will try to attend to at least a few of them.
Right. I just sent, Byron, I just sent you a private chat, and I lost Bruce's question. But I believe the question was, if I have a PCT application, is that as good? We've been talking a lot about provisionals. You can start your patent journey at a PCT application. Principally, the same rules apply. If you've put content in a PCT application, then you have it in a pending patent application. And every piece of advice I've said about provisionals would still apply. The same would be if you have it in a pending Canadian patent application within the last 12 months.
And so as long as it's still alive, right? And so you haven't let anything lapse, like that'll give you that protection, right? But you still will have to file your PCT within the year.
Now I've got my back. So let's see. I have a file. Could I discuss maybe a bit? Yes. So could you discuss? Yes, you can discuss with your customers or partners. Now, what you discuss is still a business decision. How much you want to release. Be pragmatic.
Yeah. And just before we move on to the next part of our discussion, Garth had that question. I started selling in Canada, right? So that is a public disclosure. I succeeded in 10 months and then wanted to file in China, right? Is that a bar already? And then he's added even more information. In the meantime, someone had published an article in China about what we're doing without my knowledge. How does that affect my patent rights?
Well, thank you, Garth, for the question, because one of the things I didn't get into was, generally speaking, when we talk about anticipation or when we talk about these publications, we're talking about availability to the public without qualification. We don't mean the Chinese public or the Canadian public. And without regard for language. So your sale in Canada is a bar in China. If you publish an article in written Chinese, that would be a bar to patenting in Canada if, outside the grace period. Language doesn't matter. Location generally doesn't matter. There were some exceptions to this, especially in US law, but they're gone since 2013.
And what are your thoughts with regards to, and we'll get into this a little bit further, but with regards to obtaining a patent and being able to enforce a patent, right? When someone when you do an infringement and they countersue saying that your patent is invalid.
Sorry.
So what I could see happening is you sell in Canada, which is an offer for sale, which anticipates it in China.
Yeah.
But you file in Canada within the year, which will give you protection in Canada, and then at the same time you claim priority and file in China.
Yeah.
The Chinese may not the Chinese patent office may not identify, right, your public disclosure and may issue you a patent. And so you might get the patent in China, but if you try to enforce it, hey, you're going to have to go through discovery. Someone will go do internet searches. One of the things is and you can answer this, Miles. It's like, where do patent not agents examiners, what do they typically search? Right? Are they doing internet searches or are they relying on just a core set of materials?
Well, the last week I've actually had a lot of internet search stuff come up, and we'll talk about one of those cases. Last month, sorry. They principally are looking for patent records, so sometimes that's a problem. We'll talk about that in the next section. So yes, the Chinese examiner could miss something that's out on the internet. Very, very likely. So what if you have a situation where you have a patent, it's issued, it's granted, but it's invalid? It still may be effective because it's got a problem. Nobody else does. If you ever were to assert it, the courts have the authority on the validity of patents. The patent office does not. It's the courts. So there may be creative ways to reference it without asserting it to scare people away. There's lots of scenarios where private information can be leveraged asymmetrically.
Okay,
and if I could make that answer more abstract, I'm willing to do so.
I think this is one of the discussions between like legal risk and business risk. And
Yep.
so I would say that there is legal risk that your patent application or your issued Chinese patent is invalid, but from a business risk perspective, that's still maybe good enough for you. And so you can still slap on a sticker because you rightfully have an issued a Chinese patent. You can say patent in China, and here's the number. But if you try to sue someone as an infringer, there is a very high likelihood that that offer for sale could come to bite you in the butt, so to speak, and then render your Chinese patent invalid due to the bar for absolute novelty.
No, great way of phrasing it.
Yeah. Okay, so we're going to move on to publications as defensive disclosures, which is an interesting thing that usually startups in Canada don't encounter early in their growth period, but as soon as you become successful or as soon as you start to have very large US sales, it may become an issue. And so that's with respect to being sued by a non-practicing entity or what we call patent trolls. It's always kind of a badge of honor for some startups when they receive their first patent infringement threat, and because it kind of shows that they're large enough and big enough, or someone thinks that they have money or are at least successful. And so maybe let's talk a little bit about that, about how publications can be helpful in the situations to defend against trolls or competitors broadly.
So you always have to think about things as if you're on the other side. So often with this audience, we're talking about how do you get patent rights? But you also have to think about how are other people getting patent rights? So let's go back to the notion of a publication. A publication can obviate or eliminate someone's patent rights. So how can you use this? You can take information and disclose it in a way that it's designed such that other people can't patent it. So we call this a defensive disclosure. So that's when you have an invention that you don't think is worth patenting yourself, but you don't want other people to patent. That's a defensive disclosure. And it's as simple as releasing the information to the public.
And what are the best ways of doing that?
Well, my sister always reminds me, simple isn't easy. You want to fly? Aim for the ground and miss. That's the simple instruction. It's not easy. So it depends on your industry. If you are in software, open source is traditionally the way you make a defensive disclosure. I would argue that's a lazy way of doing it. You should have a corresponding paper, an example implementation, really try and make it more likely that it'll be noticed. If you work in a field where people routinely publish, well, then you let them publish. So if you happen to be working with academics or industrial researchers, you let them publish. So what about if those two situations don't apply to you? There are defensive disclosure journals. You can pay money to an organization to publish a description of your invention.
And the reason it's important to get the proper publication is because like you could post it on your website and say, okay, well, I posted on my website on this date. But it's sometimes hard to cite your own website or the Wayback Machine in order to say, okay, well, this was available to the public at this time. And so you do, but let's say you've done that successfully. Like how do your clients, or when you've made a defensive disclosure, how do you leverage that as a shield in different situations?
Well, you hope that one, it's cited in the patent office. So IP.com, you pay about $400 US. The 10,000, well, I guess more like 8,000 people now at the patent office, US Patent Office, have access to that. And so hopefully it's limiting the claims that the patent office is allowing. So that's one thing. The other thing is, if you are ever sued, you try and come up with an argument, and it's really relevant to what you're doing. You kind of come up with an argument as to how all of, you have released this to the public and it predates or it antedates the patent being asserted against you. So you got to have good corporate records of your patent disclosures.
Mhm. So basically you're saying, hey, you've cited this against me and you want money, but I'm telling you your patent is invalid because I published a paper prior to your priority date,
Mhm.
right? And so, and
No.
you have good records that show, okay, these are all the things we filed, these are the things we've done, and we've been very open to the public about this. And
Mhm.
so go ahead and sue us, but we're just going to make your patent invalid,
Right.
right?
And they may want to settle with you right then
Mm-hmm.
because you may know about that disclosure and everybody else doesn't. So there is one trick it doesn't really work so well in the world of machine learning, but we used to do is we used to publish things in an obscure language. The Moldovan dialect of Romanian. And we amazingly would have a very accurate English translation of that article ready to go.
Yeah. Was that ever used?
Never really. We always had it ready to go.
Yeah.
Yeah.
That's so
Uh,
fascinating. And
yeah.
who came up with that? Like, is this like something like, hey, you heard someone else who did this and we're like, oh, we're going to try it and it sounds fun?
Frank Abramonte at Connor Coisen was the one who told me about this one.
Yeah.
And we definitely used it. It wasn't Moldovan. That's just my favorite language to pick on. So I've obfuscated some of the details when I used it. So
Yeah, for sure. And maybe one other kind of defensive publication or defensive use of a early publication or a defensive publication is on a notice of allowance of a competitor's patent application, right? And so, hey, you'll get a notice, but then there's an opportunity for someone to challenge that, right? Once it goes into the public register or whatever it's called. So before a competitor's patent gets issued, there is a notice of allowance, which is public, right? And there's an ability for people to assert against certain patents. And so if you have a prior anticipating disclosure, you can say, actually, the examiner didn't look at this. And so rather than have to go through very expensive litigation and get a court to invalidate a patent, it is a cheaper process to file. I think you pay a fee. I'm not sure about the details, and cite it against a competitor's notice of allowance, but prior to issuance.
And this traces on a whole bunch of issues about how much active surveillance you should engage in, and this varies with company size and the legal risks of interpartite or versus ex-partite proceedings and things like this. But it is an option that we should flag. So
yeah, and it's kind of like as Miles said, it is typically a strategy that larger, more sophisticated companies use, particularly in spaces where they know their competitors are litigious. And so, right, it's cheaper to invalidate, so cheaper to block it from getting issued than it is to try and validate it at a later date. Okay, what are some other, so we've talked a lot about filing patents and public disclosures, but the kind of opposite of that is just like keeping things secret. And so maybe talk a little bit about some of the tricks or strategies different folks can use to balance filing patent protection through provisional or non-provisional versus trade secrets versus worries around utility and enablement.
well, one option is, let's say you're mostly interested in the US and Canada. What if you say, let's forget about getting a patent in Canada, we'll just get a patent in the United States? And it's a situation where you're not sure you want to keep it as a trade secret or have as a patent. So the US is unique in that you can have patents that don't publish before they issue. They're never laid open to the public. So you can file a patent application covering this innovation, should it be a trade secret, should it be a patent, in the US and in the US only, and have a non-publication request. So to get a non-publication request, you have to promise not to file it elsewhere. Now, if it gets allowed as a patent, then you have that patent. And if it gets refused, it's a trade secret. Also, if it gets allowed, you have the option, but not the obligation to accept the allowance. Maybe you prefer the trade secret route. Now, the person who taught me this technique, and we definitely use this, we used to guide the patent applications to the slower parts of the USPTO to push that decision way down the road.
So you try to get into a particular art unit that is like notoriously slow.
Yes.
Interesting. How can you forum shop? How do you switch art units?
You use particular keywords in your abstract and the first claim is filed.
Oh, interesting.
Highly recommend it also for getting away from, if you're filing on anything to do with a business method, please do not have anything to do that in anything mentioning the business method in your abstract. You can always replace that abstract later.
Interesting.
In
Okay.
fact, free advice. Anything
Yeah.
you put in the parenthetical, e.g., for example, you can mention all sorts of technical algorithms in a non-limiting way. And that will likely forum shop you away from the business method art unit.
Yeah. And the reason being is that, right, we sit in a specific time period where business methods are struggling to get issued, right? So from a patentable subject matter perspective, is that right?
Yeah, exactly. I mean, it's been 11 years since the Alice decision, and that's caused a lot of chaos. And the rejections in certain art units of the USPTO have just shot way up.
Okay.
Let's see, what other interesting techniques you can use? There's tons of them. Talk to your patent agent.
Yeah.
You know, talk to them about your disclosure needs. Talk to them about your disclosure capabilities. Talk to them about your disclosure risks. Are you the type of company that has salespeople that can run over and just do whatever they want? That's a disclosure risk. Disclosure capabilities. Do you have machine learning researchers that actually go to conferences and publish? Well, that's an opportunity. Craft your disclosure strategy. Keep in mind, though, there's some risks of defensive disclosures. It doesn't automatically get searched by patent examiners. It's the last thing they'll search is the non-patent art. Most art, non-patent art cited by the US patent applications, it's about 20%. So 4 to 5 references are a patent document. 1 out of 5 is a non-patent document. Most of the non-patent documents are cited by the applicants themselves. So defensive disclosures, not always the best, but they're cheap.
Yeah. Yeah, that's true. So I guess the risk also of a defensive disclosure is you have to, when you file your IDS, you have to cite that in any future filing, right? And so you may think that you differentiate from your defensive disclosure, but that might not actually be true in the eyes of the patent examiner. So I think that is definitely a big risk that you need to be careful about, right? If that is something that you're
and I wrote just dealing, you know, Byron is being modest. He really is think deeply about this. I wrote down about 7 different risks. I didn't even think about that one. So, but here's an alternative, and I'm just going to step on your toes here, Byron. You know, one option to alternative to a defensive disclosure is it costs about $400 to publish with IP.com. It costs about the same to file a Canadian patent application, plus 3 years of maintenance fees. And then you have 4 years to decide whether you want a Canadian patent. So why is this different? Well, it gives you the option to get an assertable right. You can convert your defensive disclosure into an assertable right in the ninth largest economy in the world.
Yeah. Yeah, for sure. Right. And you don't need to do anything, right? You have to request and pay a fee for examination. It just won't automatically even happen. And so like it kind of just sits there for a while.
It just sits there, and you have, and at 4 years, you have the requirement, are you going to pay this request examination or not?
Yeah.
And there are ways to do this in Australia, China, Germany, but for the exception, you know, it depends what language you already have the defensive disclosure written in. So if you have it already written in Russian, then you just do this in Russia.
Yeah.
Again, lots of pragmatic decisions that need to be tailored to the individual client.
Yeah, for sure. can you maybe, I think everyone always likes fails and people can learn from fails. Any examples of practices gone horribly wrong where it's worthwhile highlighting?
So I have a client that used their invention in a certain way and then filed a patent application. And I asked him for all the references that predate his patent application. Then the examiner, really nice man, really listens, was really pleasure to talk to him, said, yeah, so I did a Google search and I found your client talking about using this product. And that reference came after the filing date, so I didn't ask the client for it. So it created a prima facie suggestion that the invention lacked novelty. And this guy was like, oh yeah, no, we used it for 2 years. He didn't actually mean 2 years. He meant 2 seasons. He meant, and so I'm going to have to walk that back.
Yeah.
Too thin provisional. That's a very common fail. Let's see, what else? IBM itself, Xerox, they closed their technical disclosure programs because they didn't see ROI. Anything else? I once had an academic give me a paper, very complicated area, tons of math. I spent days and days and days translating it into English and filed a provisional patent application on the day he wanted to submit it to the journal. Great, done. And then he calls me up and says, oh, the last third of the paper, there's a mistake, and I corrected it. So I went to my boss and I said, look, let's just spend a little bit more money. I'll fix it and we'll file a provisional application this day. He's like, oh, no, it's fine. It wasn't.
Yeah.
So, and all that work I'd done. That's about it. I mean,
actually, one question I had or that I thought about, which we haven't covered yet, is the use of NDAs. Right?
yes.
So we see that fly around a lot. How does that work or vitiate? Right? How does that interact with the public disclosure rules?
So an NDA, or as I prefer to call them, a confidentiality agreement, is an agreement between 2 parties to keep something secret, non-public. So you can release something under a confidentiality agreement, under an NDA. It doesn't affect your patent rights unless this party discloses that information. Now you have a public disclosure. You can sue that party, but you still are dealing with a public disclosure. So in everything, I really, really recommend provisional patent applications are often a better alternative to an NDA. You don't have to burden the counterparty with asking them to sign the agreement. Some won't, like a VC. And you have proof that the invention was yours before the meeting.
And I think that's actually a really good point. And maybe I will publicly state it on this channel that my fund doesn't sign NDAs. Like we see hundreds or thousands of companies, and just the brain bashing that would be required to manage that number of contracts is something that we're just not willing or capable of doing. And so if you're about to do a fundraise and patents, and you're worried about public disclosures as vitiating your ability to file in certain jurisdictions, right, you may want to file prior to starting your round, because I guarantee you a number of your investors or potential investors that you're going to approach will not sign your NDA. Okay, we're coming up to time, so we're just a few minutes over. I want to quickly ask if anyone has any additional questions for Miles before we sign off, and then maybe while people are typing their last questions, maybe Miles, I'll just hand it over to you for any last words, any additional best practices or tips that you want to share with this group, or any topic that we had discussed on our prep call that we haven't covered in today's conversation that you thought would be important and relevant for this crowd?
Well, as always, talk to a patent agent. The profession in Canada is called patent agent. So you can be a lawyer. So you'll have someone will carry a business card that says barrister, solicitor, and patent agent. They can represent you in Canada and the US. Talk to them about public disclosure strategies and your filing needs. Get advice tailored to your company. Don't just copy advice that works for another company. Let's see anything. One thing we didn't get into, which is important, is if you rely on grace periods and another person publishes the content that was to be in your patent application, you can't get the patent. Grace periods aren't perfect. And I'll leave it there.
Coming back, so if someone learns it from you and then republishes it, then you can't?
No, they have to come up with it independently.
Independently.
If
Okay.
they've learned it from you, that's fine.
Yeah.
Yeah. Let's see.
But it's also if they've added to anything, right? So you may not, hey, I have this feature coming down the line,
Yeah.
right, which would be in your patent application, but you may not have actually shared yet. You could lose, but because you're kind of leading them there sometimes.
Yeah, you're kind of leading them there. That's sort of one of those weird gray areas where, but yeah, that's a risk. Luke's got a great question. It's about patent eligibility. That's a whole can of worms. You know, an application to automate manual administrative work really depends what you're talking about. If you're claiming it as the administrative work, then no, you probably can't get a patent. If you're doing something technical to enable the automation of that that administrative work, then yes, you probably can get a patent application, provided it is new, useful, and non-obvious. Sorry, provided it's new and non-obvious.
Right, but copyright would always apply if you're releasing source code,
Yeah.
because that is copyrightable.
Yeah.
So it would be a layering of rights. So you could try and rely on copyright, and I don't know many that do.
Yeah, you could try and rely on copyright. And don't forget, most software these days is sold as software as a service. So you also have a trade secret option. Brad's asking about publications and how they might adversely affect your design application. Yes. So your patent application, with the exception of the US as discussed, publishes or is laid open 18 months after the priority date. So that can affect your design rights, because when it is laid open, the effective date of it is actually reverts to its filing or the priority date. So you have to coordinate between your filings. So you could have a utility patent application in the United States disclose the design, and then you later file a design application. There's potential for prior art. Gets really complicated, and it's a lot more complicated in the United States, where they hold that a design patent is a patent. The rest of the world, we don't call it a patent. So in Canada, the answer is slightly different. But the answer, have a plan, coordinate your filings is the basic advice there.
Yeah. And actually so I don't know much about industrial design, so I'm not going to comment on that. But the difference between when you file and your publication date actually does matter when it comes to anticipation and obviousness, right? So, right, if you have competing filing dates, something can anticipate you even if it wasn't available to the public, but it just was there, right? But it doesn't actually work from an obviousness perspective. So Miles, correct me if I said that right, or
yeah,
opposite.
I mean, there's a flow chart on anti-dating references.
Yeah.
And it's about 16 different outcomes, and about 7 decisions. So, because some of them collapse to each, it's not 32 or whatever, but yeah. There's some weirdness. Again, though, having a coordinated filing plan, knowing what's in your applications, not oversharing. Lots of startups want to put way too much in the patent application. Sometimes if you have a patent program running, there's nothing wrong with having patent application on topic A and purposely stopping at some point, because you might want to file a patent application on the improvement. Some people just want to get it all in there. Lots of executives like, well, why didn't you put this in? Well, because we're going to file a later patent application and we don't want the early patent application to interfere with the later. Because you don't want to be arguing, when you're in patent prosecution, what we do is we attack the references cited against us. You never want to attack yourself. So sometimes, especially when you've got a well-oiled patent program, you want to be very clear where this is the bounds of this topic, and we're stopping there. And if there are improvements, we'll file them in a later patent application.
All right, I'm gonna punt on Mark's question because I think that's a topic for another day. Like, let's dive into novelty, and it's not the topic of this discussion. And so,
Actually, I'm going to do a shout out to Bradley and yourself. Organized a talk a few months ago by Joanna Ma and Annalise Parsons of Bearskin Par. He might find some answers to his question on that, and that's available on the New Ventures BC website.
oh, thank you for that. And so with that, I'll give any last words to Mile. So thank you for joining us today, and thanks to the audience for participating in today's discussions with lots of questions and showing up, right? I think it's really important to provide this material to our community so that they are well informed on how to best organize and move forward in their own IP journey. Contact information, Miles. How can people reach you if they have any questions or want to talk to you further?
Miles, MILES at perpetualpatentsplural.com. Please, if you have any questions, be happy to answer them. And if you're on this call and you're not familiar with the resources from Accelerate IP, New Ventures BC, please get familiar with the education, planning resources, office hours with Chen Han. There's tons of free resources available to you. Please make use of them.
Great. And that'll be the last words. We will probably be back in the fall, but we do not have that scheduled yet. If there are any topics that you feel you would like this webinar series to cover, please reach out to Bradley with those suggestions, and we'll consider them as we go through that planning process. And if there's any other feedback, we're also happy to accept that as well. And so with that, I wish everyone a good afternoon. Take care, and I'll hand it back to Bradley for final words.
Nope, that's it. I just want to say a big thank you to Miles and Byron for today's talk, and check out the links I've added in the chat for anything that has been referenced so far, and we hope to see you at the next one. Take care, everybody.
All right. Thanks, everyone. Take care.